Get ready. 3 seconds. 2 seconds. Start. The present appeal is directed against the order, dated 14/10/2004, passed by the learned civil judge, in money suit number 26/2004, whereby the learned court has rejected the plaintiff's show filed by the appellant. Para. The appellant plaintiff filed a suit for damage and compensation against the respondent in the tune of rupees 50 crores, raising certain allegations against the respondents who have indulged into various antisocial activities, illegal extortion by use of manpower and muscle power against the appellant in series of acts, as has been narrated in the plaint. In news item published in the Assam Tribune on 4/2/2003 has also been challenged. The appellant also filed a petition under section 80(2) of the CPC seeking leave of the court to file the suit. During the proceeding, 11(d) and Rule 11(e) of CPC for rejection of the plaint, to which the appellant filed written objection. Para. The bone of contention of the defendants respondents raised in those petitions is that the suit instituted by the plaintiff without service of notice under section 80 CPC is bad in law. Further, contention was that the plaint is not accompanied by verification and affidavit as required under section 26 with order Roman 6, Rule 15 CPC. It is also alleged that the case was filed after 1 year publishing of news item in the Assam Tribune, so, the case is barred by section 75 of the Limitation Act. Non-compliance of provisions of order 4, Rule 1 for not presenting plaint in duplicate is also assailed, and on the above mentioned grounds, it was prayed to reject the plaint. Para. The plaintiff appellant resisted the objection that the procedural defects for non-submitting copy of plaint and verification and affidavit, etc., is curable irregularities, which can be allowed by the court. Para. I have considered the rival submissions of both the parties and perused the lower court records and the impugned order. It is to be noted that respondent number 7 is the editor of Assam Tribune, and obviously he is not a government officer, and as such he has no locus standi to challenge the violation of section 80(2) of the CPC. However, as the matter has been discussed in the impugned order, the learned counsel for the appellant has relied upon the case law reported in AIR 2002, CAL 11 and AIR 2004, Delhi 225, wherein Honorable Supreme Court held as follows. Another ground of appeal that the point of limitation being a mixed question of law and fact, the court below cannot reject the plain at the threshold of the case under Order Roman 7, Rule 11, CPC, and as such, it is liable to be set aside. Full stop, para. In the present case, whether the limitation will run as per Article 75 or 113 of the Limitation Act is to be adjusted on the appreciation of evidence. Full stop. Similarly, while deciding to accept or reject the plain, what can be seen is only the abutments made in the plain. Full stop, para. In view of all above, I am of the considered view that only on the basis of submission of one of the defendants, the court should not reject the plain at the threshold of the litigation. Full stop. Accordingly, the impugned order is hereby set aside and the matter is remanded back to the court of learned civil judge, with a direction to proceed with the case as per law and prescribed procedure as has been held in the decisions above mentioned. Full stop.